We're so excited to have you all here. This is the third in a series of 5 criminal justice reform conversations that we're holding in connection with the SMU Law Review's 2021 symposium. That symposium brings practitioners and professors into conversation about criminal justice reform. We've previously had 2 other conversations, one about policing reform and accountability, and one about racial injustices. You can find those conversations on our YouTube channel. But for today, it's my pleasure to introduce our guests who are going to be talking about bail reform, a subject that for many of us who are joining on this call today is near and dear to our hearts. It's certainly a topic that's on the agenda across the nation, and so it's a particularly important moment at which we bring these 2 wonderful guests together to talk about it. Our guests today are Professor Shima Baughman, who is a professor of law and criminal procedure at the University of Utah College of Law. She is also the Associate Dean for Research. Our other guest is Amanda Woog. She's the Executive Director of the Texas Fair Defense Project, where, among other things, she led the TFDP in starting the first adult public defender office in Travis County in Texas. So with that and their very brief introductions, because I'm eager to get to the conversation, I'm going to ask if Professor Baughman will start by just setting the stage for us and just filling us in on what is bail reform and why should we be thinking about it?
Great. Thank you so much, Professor Metzger. It's great to be with you as well, Amanda. And I'm so thankful for SMU to be able to provide me this opportunity to talk about bail, which is definitely my favorite topic and very near to and dear to my heart as well. So why does bail matter? I love to talk about that because I think even though it's, kind of a topic that we are hearing about in the criminal justice reform world, it's important to kind of remember why it matters. I think one thing that's kind of not really talked about as much when you think about bail reform is that the reason why bail ends up mattering so much more now is partly because the criminal trial has become a sort of unicorn, and it has been for many years, almost like 50 years. But, we have this criminal trial that's supposed to be the place where, you get your day in court, your due process rights are protected, but we don't have that. And so what happens is every hearing before that becomes that much more important, especially the earlier hearing. So in my mind, the most important criminal justice touch points are arrest, and then it becomes the next thing, which is the bail hearing, where you either are incarcerated or not. And that one little decision, sometimes 1 minute of a judge's time or magistrate's time will really determine that defendant's fate. It determines whether they plead guilty, whether they serve 3 times as long in jail. It determines whether they lose their job, potentially their home, their child care situation. Oftentimes they're 3 or 4 times more likely to be convicted or incarcerated. They're more likely to plead guilty. If you talk to defense attorneys, they'll tell you this is the most important decision. Even prosecutors way prefer to have their defendants behind bars and not get bail because it just makes things easier for prosecutors. For defense attorneys, their dream is to have their defendant, their individual released. And so I don't think it's an exaggeration to say that bail is one of the most critical early decisions that we make in criminal justice. And also that we would be able to solve jail overcrowding if we were able to solve our bail problem. So that's kind of, let's put in context. And then let's talk about what's going on right now, which is so exciting. So the last 10 years, I would say we're, in the midst of what people are calling the third wave of bail reform. And, hundreds of jurisdictions are working on reforming their bail. We have lots of different tactics to do this, right? Some are getting rid of money bail, which is amazing. Some are putting in risk assessments, which are also, some of which are great, and improving, looking at data rather than relying on gut instinct, which we've been doing much more so early on. And the thing I want to think about and kind of put in context is, and why I wrote this, my submission on this is that the last 2 bail reform movements in the 1960s, and then we have the 1980s, 2 acts, federal legislation, and lots of states followed, were aimed to improve bail. They were all meant to increase defendants' rights, to prevent unlawful detentions, to get judges to stop relying on money bail. But they didn't work. So none of those things happen. And, if you look at what's happened in those years, from 1970 to 2019, the number of people detained in jails prior to conviction has risen 433%. And from 1990, just kind of looking right after the bail reform movements, but after some key legislative lobbying by the bail industry movement in 1990 to 2019, state pretrial detention rates have risen 77%, and federal rates have risen as well 20%. And so there's something going on, right? The bail reform movements have not decreased detention, and the efforts that we've made in the last 10 years have really not worked either. So what's going on? What do we need to do differently? That's what I want to talk about.
Thank you so much. And before I hand it off to Amanda, for the benefit of the students who are with us today, I want to give a little legal framework as well here to what Professor Baughman just said, which is that historically, bail was only allowed as a mechanism of forcing people to come back to court. In reality, judges were often holding people because they believed they were dangerous, but setting a very high bond amount saying it was because they were afraid the person was going to flee. And so while there has been a movement towards transparency and allowing judges to explicitly detain people because they're dangerous, in other words, to be candid about those detentions, it was not accompanied by an effort to reduce very high bail amounts for people who did not need to be detained. And so one of the conversations about jail overcrowding and the kinds of things that Professor Baughman was speaking about is that the vast majority of the people who are in jail are not there because no bail could be set. They're there because they could not manage to meet the amount of money that was being requested. And so that's kind of the legal background for those that haven't had exposure. Amanda, can you talk about what's happening here in Texas in the area of bail reform?
Absolutely. First, thank you, Professor Metzger and your colleagues at the Deason Center and the students at the SMU Law Review and Professor Baughman. It's really a pleasure to be in this space with y'all today and for the invitation. So Professor Baughman is 100% correct that this is a critical moment in what we call bail reform. We're in the third wave of bail reform after seeing a couple, I think, fail by a lot of our standards. And we're at a critical moment where we could see that happen again, right? Or we can learn from past mistakes and movement that's happening on the ground right now to learn about what bail reform can and should look like. And Texas provides, I think, a really important example, and in some ways today, a warning sign as well as to what the various directions are that we could go in. Of course, Texas always thinks, as Texas goes is the expression. We always think that we're leading, but in some ways we also offer, I think, warning signs of what could be to come. And so I'm going to just talk really briefly about recent movement in Harris County that we were involved in to kind of set the stage for the various directions that this movement could go in. And I think why, our organization in particular is really concerned with what we see happening on the ground in local courts and grassroots efforts to change the pretrial justice systems. So in 2016, Miranda O'Donnell was 22 years old and she had a 4-year-old. She was a mother, and she was arrested in Harris County for driving while license invalid. And a lot of us know that so-called crime, a Class B misdemeanor, is what we call a poverty crime. And it usually has to do with someone's license having been suspended because of inability to pay. These are cases that we at Texas Fair Defense Project deal with all the time. Now, because the hearing officers in Harris County were relying largely on a bail schedule, which is like quite literally a chart that they'll look at to determine what bail amount should be set, Ms. O'Donnell's bail was set at $2,500 and she couldn't pay. So she was held in the Harris County jail, where about 9,000 human beings are held on just about any day, and away from her family, because she could not come up with basically $250, which is what the bondsman fee would be, to get out of jail. Ms. O'Donnell became the named plaintiff in a class action lawsuit that was filed by Civil Rights Corps, Sussman Godfrey, and Texas Fair Defense Project in 2016, challenging the system basically on the grounds that preset bail created a de facto order of detention against people who could not pay their bail. So if you had money, you got out. If you didn't have money, you stayed in. And this is what people recognize as the problem with the cash bail scheme. Fast forward a couple years, there's an 8-day evidentiary hearing in the district court. The case moves up to the Fifth Circuit. And the Fifth Circuit recognizes the problems with the system, but the remedy that they give is largely a procedural Band-Aid. And as part of that procedural Band-Aid, they require that courts take into account ability to pay. They also require a hearing within a certain amount of time, but it's basically trying to bring process into these bail setting hearings. At the same time, the judiciary turned over significantly in Harris County. And we saw a wave of judges come in who campaigned on bail reform, who wanted to settle this lawsuit and create a different kind of pretrial justice scheme in Harris County. So you have this law that was created by the Fifth Circuit as part of the litigation, but then two, you have this consent decree and rule that was issued by the Harris County misdemeanor judges that actually looks pretty different from what the Fifth Circuit described as like the new constitutional legal requirements for setting bail. And so in Harris County, the rule that the judges came up with and was ultimately memorialized in the settlement and the consent decree basically said that the vast majority of people charged with misdemeanors should be automatically released from jail on a personal bond without having to pay anything. They also got rid of pretrial fees. So just trying to get money out of the system entirely and put into place more common sense things like text message reminders and ways to help people show up to court who are then out on personal bond. So I think what's kind of interesting about where we are in Texas right now, having seen the Fifth Circuit come out with this like procedural Band-Aid and then having Harris County come out with this more sort of like substantive reforms to their cash bail system is we can see how in almost the same instance, there have been two tracks for what like bail reform will look like. The last thing I'll say about bail reform in Texas today, which is another word of warning, bail reform is something that you see on the page of the New York Times and every major newspaper. It is such a buzzword that it's lost meaning in a lot of ways, which is why I think a conversation like this is very important in this very moment, because a lot of people will usurp the idea of bail reform to do things like Professor Baughman mentioned, which is expand preventive detention, expand the net of people who are going to be jailed. And that's something we need to be really careful of. I won't go into details, but we're seeing some of that pop up in the Texas legislature right now. So Texas is really seeing a lot of different possible movements, and I think is a really exciting time and place to be examining what the future is of so-called bail reform.
Thank you for that overview. So I think what I'd like to do is I want to talk about a few key points that have come up about what possibilities are and what the challenges are with compliance. Now, partly I'm seeding the pond here because one of your essays is about what are the 7 key steps that we should be thinking about in terms of bail reform, and the other is what do we do about non-compliant judges? Professor Justin Murray, who I think is attending the webinar, has written about how you police procedural error. Sandy Mason's on this call. She's written about some of these things. These are hot topics. And so I want to start by asking about a really, I think, under-discussed but important feature of our bail system, which is the detention of people for no-shows rather than for flight, and what the difference is and why it is that understanding what practitioners refer to as an FTA, a failure to appear, it is key to making meaningful bail reform. Shima, can you start us off on that?
Yeah, absolutely. Love to. I have to give all credit to Lauren Goulden from Syracuse for bringing this to the world and this understanding, but it's something a lot of us missed. But what basically, so historically, if you think about bail, there was a concern of flight risk. And so as you described kind of perfectly earlier, Professor Metzger, the way it was is that it was kind of, before you go back to trial, you're released and then you kind of are, come back. And part of that determination was the only determination really was, were you charged with a capital crime? If so, you're detained. And the second question was, are you a flight risk? right? If you're a flight risk, meaning you're going to leave the jurisdiction, they were careful to detain you. And flight risk, which was a kind of a very carefully defined term of people that were, going to flee. And so in those circumstances, they would take the passport, they would see if they had means to flee. That has been interpreted in our day and age to failure to appear. So basically anybody who doesn't show up to a court hearing is called a, failure to appear and is made more risky. And this is something that, Lauren, as well as others have now keyed in on, is people are now on these risk assessments, right? A lot of state risk assessments, they say if you have prior failure to appear, if you are at high risk of failure to appear, you should be detained. But there's so much evidence now that you don't have to be detained. You can just be reminded through text, through email. I mean, there's so many successful ways to keep people coming back to court. I mean, DC has, pretrial agency that makes, I think, about almost 90% of people reappear at their court dates. I mean, we can do this, right? We can get them to come back without detaining them. And so, yes, this whole failure to appear thing has been a clever way to kind of, have a lot more people detained than we need to.
Let me also just say that Nate Fennell, who co-authored Amanda's piece, right? Nate used to work in a pretrial services unit in New Orleans, where one of the things he worked on, right, was this very issue you're describing, getting people out on bail, but then finding ways for them to come back. I mean, in many ways, the FTA problem, the failure to appear, is a crisis of poverty. And it reflects a lot of the class and economic discrimination that's at play in the bail reform movement. Amanda, how is that playing out in terms of communicating with the judges, making things happen in state courts that should be happening, to follow along with this recognition about appearance, rather a difference between appearance and flight?
Yeah, I mean, the difference is exactly how Professor Baughman described it. But one thing that I've seen recently that I found really interesting was that I saw a stat that the Bail Project has a 90% appearance rate. And for folks who don't know, the Bail Project is a national bail fund organization that has offices on the ground in Texas and in other places as well, that will post bail for people so that they will be released from jail pending trial. And this is kind of I think a really interesting community-based workaround to the unjust pretrial reliance on cash bail. But that 90% number, I testified in the legislature recently and mentioned that, and I remember the eyebrows raising across the committee, because that's a really high number for appearance. And what that says to me, the Bail Project has caseworkers who are available to people and otherwise offers support for folks to be able to show up to their court appearance. And what that says to me is if you give people the resources and opportunity to come to court, they want to take care of their cases. They want to get them over with. I think a lot of the issues with appearance have more to do with lack of access to public transportation, childcare, all the things that you can think of, the reasons that make it hard for people to keep medical appointments or things like that as well. The other thing that I found really interested about that and really have started thinking about with relation to the Bail Project is that in a lot of places where you have higher release rates, and this is in Travis County where Texas Fair Defense Project is, you see pretty robust pretrial services offices. And that's something I want us to be really cautious of, because a lot of times these offices will just introduce other modes of surveillance of marginalized communities and also wealth extraction. So like really astronomical fees that are attached to the so-called services that are being offered when people are out pretrial. So another thing that got me really excited about seeing the Bail Project statistics is that they're really offering a community-based nonprofit model for what we might otherwise call pretrial services that I think is really exciting and that we should be exploring as we're moving ahead with trying to reduce these jail populations and giving people the support that they needed in the communities that they're a part of.
So I'm gonna make a comment and then ask a question that may be on y'all's minds as well. The comment is that, again, this tracks with something that Professor Baughman wrote about, which is the importance of data, right? Keeping good, solid data on pretrial detention and outcomes. But I want to push on this idea of bail funds for a moment, because one counter argument to bail funds is what you're really doing is you're simply making it possible for court systems to continue with a cash bail system that ought to be abolished by essentially supplementing it so that they can feel good about a cash bail system, because anybody who can't make bail will be released by the bail fund. Therefore, we don't have to think too long, too hard, or too deeply about this problem. What's the response that either of you would have to that critique?
Yeah, I have the same problem with that whole thing, the bail fund, because it's like, it's almost like when you get into litigation and you're like, if you find my client not guilty of this, then it's like you're making your kind of like less good arguments. And it's like, should we just stick to, for those of us interested in bail reform, which is like this conversation, I mean, should we stick with just, we don't believe in money bail. It is unconstitutional. It is out of the norm of the world. It is, against what we stand for. It's, violates rights, et cetera, et cetera. And should we not have these funds? But yeah, at the same time, there are people struggling, and that $250 bail, will save one person. And it's like, does that mean, if you can't just put your hands up and say nothing? I mean, I have to say, frankly, I am a little bit excited when I do see bail funds pop up. Like there's one in Salt Lake City that's formed, and it is exciting because it's something that's, in the meanwhile doing something good. So I can't really be angry about it, because ultimately I do think money bail should be removed completely. But in the meanwhile, am I hurt that people are being helped by this? Am I bothered by that? I'm not. So I don't know, maybe that's puts me in the exact same position as you are, but that's where I'm at.
Yeah, I mean, I will say my view is sort of that it's much like the conversation I had with Bennett Capers not too long ago on one of these calls about abolition, which is that there's sort of an elitist piece of being able to say bail reforms are kind of allowing the system to co-opt progress. That's really easy for me to say because I'm not in jail. Amanda?
Yeah, I think I might take a slightly different view, which I see it as a yes and. So the bail funds that we've worked with, like I know Krish with the Texas Jail Project is on the line right now. They have worked with the Bail Project on releases. I know a lot of folks who are doing, who have revolving bail funds are doing both really. And when people are, get out of jail, the folks who want to do it, like understandably, a lot of people just want to go home with to their families and don't want anything to do, with the jail or movement around it, until they have to face their case. But some people, those stories are really important stories to be told, and they become part of the advocacy movement. And I think that bail funds really bring into focus this injustice of cash, because you have a person who otherwise would not have gotten out, who then goes home to their family and their job, who could be in jail still today. So I think in the application and what I've seen, the organizations who are doing this have a systemic approach at the same time as they're bailing people out. And I think it's really important for folks who are working on systemic change that they meet people where they are at the same time. Too often our focus on systems can be to the detriment to individuals, and people can be hurt along the way. So I think we also need to have an almost like harm reduction approach to bail at the same time. And I'm really inspired by the organizations who are pulling off the both.
So I'm going to ask then a similar question, different problem, but bail schedules. One of the conversations that I have with my students all the time when I teach this topic, and I'd love to hear y'all's thoughts about it, is bail schedules, I think, are patently unconstitutional, right? They're not individualized. They set kind of a benchmark so that once someone finally has a lawyer who can argue, they're arguing against a bond that's been presumptively set, rather than arguing about the specific facts of their case. But for those folks who get picked up and whose families can put together the money to post the bond on a bail schedule, bail schedules are an enormous boon. They can save you from spending a single night in jail, or 2 or 3 or 4, while you're waiting for a court hearing and a bail determination, or in many cases, waiting weeks for a lawyer. What do y'all think about bail schedules?
I think, I'll start again just because I do agree with you. So I think the benefit you mentioned as well, some people can get out is one. Another one is a sort of kind of equality amongst the defendants. So one of the things I highlight in my bail book is is two very similarly situated people. One is white and one is black. They're both charged with DUIs. They both have previous DUIs. One, the same judge gives one of them a much higher bail amount than another, and there's no bail schedule. And so you think, could a bail schedule help this sort of bias that people of color might face with some judges? But with that one, I think I'm more of the feeling that we should get rid of them, because it really does kind of foster the system of money and this idea that if you have a certain amount of a certain risk level, you should pay more or less. And also, because people are rich, then they often achieve the release, and people that are poor that don't. And it has nothing to do with kind of public harm. It has nothing to do with the amount they're able to pay. Overall, I think bail schedules are a terrible thing. I think a lot of jurisdictions seem to be doing away with them, though. I have to say, I mean, as far as lobbying from the bail industry, this is something they do like, because as you've seen, and some people have seen, something I kind of wrote about in one of my articles is just that bail schedules have changed. I mean, what we used to charge for a felony, a very strict felony, like a $20,000 bail, is now what we charge for a misdemeanor. So the numbers, once you get them on a schedule, they can just be bumped up, and lobbying from the bail industry directly to sheriff's offices and magistrates can do that. And so it is a dangerous instrument, and I overall, hate it.
I could just say ditto to that. I mean, I think that I think sometimes it can be tempting, especially when it comes to people being released from jail, to think of what could be a more efficient model. But Professor Baughman, in the piece she submitted for the symposium, I think really focused in on narrowing the net of people who we're even talking about. So having a strong presumption of pretrial release, and having 90% is one number that she put out there, the vast majority of people released, so that when we're talking about efficiency, that's what we're really going for, and not using a bail schedule, which only serves the bail industry, and I think reinforces this reliance on money.
So there are multiple ways that both talked about for managing bail reform. One is legislative reform, one is action, kind of by community action. What about lawyering? What's the role of lawyering in bail reform?
This is such an important question, and Texas Fair Defense Project has been co-counsel on class action lawsuits that have challenged pretrial wealth-based detention schemes. So, of course, that in itself just speaks to, I think, how we see the value in that. But more and more, and this is part of what I wrote about, I am inspired by the community models towards pretrial justice reform. And I think, for one, I think your question depends on what lawyer we're talking about. So are we talking about a civil rights lawyer? Are we talking about a public defender? We could probably think of other kinds of lawyers, but I think those are probably the two that interact with this issue the most. I think, on public defenders, or, in Texas, it's really, we have more appointed counsel than we have public defenders, even though we're changing that hopefully pretty rapidly. But I think that as far as defense counsel's concerned, there's a lot more that could be done in engaging in this issue. And that comes from supporting organizers and court watching, or getting access to bail hearings, which are incredibly closed right now. But it could also come with just advocating for their clients in bail hearings, which we don't see a lot of in Texas or elsewhere. And I think, as far as civil rights litigation is concerned, there's obviously a lot of room for that. But I think the most powerful examples are really done in tandem with organizers who at the same time are pushing for political accountability, as well as accountability within the courts. So I really think we need to be looking towards the folks most impacted by this issue, their families, and the people who are serving them, to understand the best role for lawyering. And I think if we asked, they would probably tell us. Just the closing on that is that I just want to flag in particular, public defenders and appointed attorneys can and should be doing a lot more, not only on systemic bail reform, but also in pretrial representation and representation in bail hearings.
I love that. And I think since Amanda can't toot her own horn, I have to toot her horn, and ALEC, Civil Rights Corps, and all the ACLU, and all of the great, there's, lists now of national organizations, Vera Institute, et cetera, so many great organizations working on bail reform. Without these lawyers and, bringing this high impact litigation, representing these individuals who would otherwise not be heard at all, right? Some of these people charged with misdemeanors, and as we know, misdemeanors get lost. No one cares about them in the criminal justice system. Even academics didn't care about them until, the last, I guess, 8 years or so. So anyway, I think just, kudos to all of that, because I think, and this is what makes this conversation so great, is that we are having lawyers and academics kind of talking about this issue, because this is one issue where I think, the scholarship from the academic side, and some of the great people you mentioned earlier, Professor Metzger, and also, Amanda and ALEC and all the great lawyers we've had on this issue have really kind of worked in tandem, but on different things sometimes, right? I mean, the money bail issue has really been handled by the lawyers, trying to, go strategically, county by county, ensuring that money bail is, found unconstitutional, because it is. And so just all these different things in the California efforts, of course, and Illinois. And anyway, so I'm so grateful for all of the lawyering. I think this is one of the most amazing places where lawyers and law professors have really come together to make a difference.
So let's talk about lawyering for a minute. And in particular, I want to talk about two things. One, the fact that there is no right to counsel at bail, right? And at least I believe there should be one. I know lots of the folks on this webinar believe that the Constitution provides one, but it has not been acknowledged, right? It has not been acknowledged by the United States Supreme Court in a way that's made that meaningful. And frankly, in view of the right to counsel crisis in this country, and the initial appearance crisis, the fact that most people don't have a lawyer at their initial appearance, right? You're not entitled to have a lawyer be there at your first court appearance. What are the next steps in making sure that people are represented at a bond hearing? How do we do that? What does bail reform look like in that regard?
Okay, I didn't see you unmute first, so I'll go first, Amanda, but I'm sure you have a lot to add to this too. So yes, one of my 7 points, right, is it's absolutely critical that we get everybody representation at bail hearings. And I want to be careful in how we say this, because there's some states I've seen on these, national compilations of data that say that the states are receiving counsel at bail hearings, but really there's like a couple bail hearings, right? There's the initial one, and then there's the one that people call the bail hearing. There's a lot of terminology in different states, and there's nothing even close to uniformity nationally. But what we really do need is representation for defendants at whatever the early bail hearing is, whatever the determination of bail happens. If it's 1 minute on Zoom, we want counsel there, right? Not just at the later one when they sat in jail for 2 weeks, because that's what really is the problem. And what I said in my submission and in the SMU Law Review, it will come out, is that if we don't allow defendants to have this critical hearing and have counsel at this critical hearing, then we need to release them. Then we need to have a 90% release. We will detain the people charged with very forcible felonies, first degree murder, second degree murder, some of those really, really serious crimes, and those that need to be detained temporarily for DUIs or domestic violence things. But everyone else we need to release. I think we need to do that anyway. But I think especially with this threat of counsel and Rajarthi, I don't know how you say that properly, that Supreme Court case that came down, really did promise counsel at these critical hearings, and everyone would agree that bail is a critical hearing. So just taking that next step, I don't think we're that far on the law of it. I think we're there. I just think we need to kind of, I don't know, we need Amanda to challenge us and take it to the Supreme Court.
There is this, I'm going to pass it off to Amanda, but I want to note there is this really interesting tension here, because Rothgary, which is a Texas case, right? It's out of Gillespie County, says that the right to counsel attaches at your initial appearance, but you don't have a right to have counsel actually there. It's like having a credit card come in the mail. You've been approved for credit. Your initial appearance, you're approved to have a lawyer, but you don't actually get the credit to run until you've called the 800 number. You don't have a lawyer until a judge has dialed that 800 number and a lawyer shows up. So that's a Sixth Amendment problem. The right to bail comes from the Fifth Amendment. And so the two kind of miss each other, right, in translation there. Amanda, what are your thoughts on that?
Well, I got to shout out our founder, Andrea Marsh, who litigated Rathgarian, who might be in the audience here. But Booth v. Galveston is pending right now in the Fifth Circuit, which our friends at the ACLU of Texas filed, which does bring up this issue of counsel at initial bail hearings. I agree with everything that you all said about the importance of it, but I also want to caution a little bit about this tendency that we as lawyers have to like slap a lawyer on it. There's a warm body problem in public defense a lot, which is that you have a lawyer and that legitimizes the system and legitimizes in a particular case, but your lawyer isn't actually providing quality, meaningful representation. And most people who are sitting in jail pre-trial in Texas right now have lawyers. They didn't have lawyers at their initial bail hearing, but they have lawyers who are not filing motions to get them released. And this is one of the things we really pulled our hair out around during the COVID-19 pandemic, when, the ongoing COVID-19 pandemic, trying to help people get out of jail, knowing that these were going to be some of the worst places for folks to be during a deadly pandemic like this, was getting defense attorneys to actually do something. So I think it does help to like literally put the person in the room, but you kind of have to do that. And there's not really a guarantee that that person is going to effectively argue the case. That's also something that we've heard or that we've seen. We see form motions. We see, even though there's a right to an individualized assessment, giving no individual facts or information about a client or their case. So I just want us to be cautious there, because it's an instinct that we lawyers have a lot. I do really like in Professor Baughman's paper, the 7 factors that you name, I think are great, but what I really love about it is I think they're incredibly important as a package. And if not as a package, in like descending order of importance. And the narrowing of the net is really important in the first instance. And so I think if that's the focus, and then the folks who do not fall into that 90% or whatever that number is, then get an attorney. That attorney, one, won't have dozens of other clients in jail pre-trial, probably. So we'll have the bandwidth in their individual practices to better represent their client. And 2, the courts will just have more resources to be able to hold individualized hearings, like the ones that are required under the Constitution. So I worry sometimes that this focus can crowd out other focuses that I think are actually more important. And I think it should go along with a massive net reduction in the people who even come to the point where they need hearings.
And if I could jump in on this one, I completely agree. And I love your point, Amanda, 1000% agree. I think the critical thing, you're right, because people could say, well, we gave counsel access to counsel. So we met one of your 7 steps, like kind of like it's like an and test. It's not an or. If we need, and the critical one, like you said, the most critical of the 7 to me, or just well, as we both agree on, is one is kind of changing the presumption. So the presumption should be release. And you have to set up your law that way. So many of the laws are not set up this way. Illinois' one that just came out, it's we'll see what happens, but it seems to be set up as the presumption to be released, which is a good thing. Many of the bail reforms I've seen are not set up that way. So that's one. And then the second is some sort of goal and a net, a very narrow net to get, kind of only the most dangerous that we talked about, forcible felonies. Everyone else should be released. And it's not like, look, we're letting them get away with murder. No, we're just letting them meet with their lawyer and be with their family for the whatever time until their trial. Like, no one's getting away with anything. I mean, right? So anyway, yeah, I agree with you 100%.
So I'm going to switch gears for a minute and ask about kind of local variation, because this is something you've both mentioned, this idea that, we deal with different state constitutions that have different provisions. We deal with different local practices. One of the things we think about at our center a lot is about the difference between what goes on in urban areas, where a lot of the study is, and what goes on in rural areas. We know from a lot of the amazing work that the Vera Institute has done, among others, that in fact where we're seeing a lot of jail population growth is in rural communities. And so I'm curious if you all have thoughts about how we think systemically about net narrowing, about those kinds of problems in this patchwork we have of criminal justice systems, plural.
I mean, this question is kind of everything in some ways, because none of this matters if you're not seeing it play out court by court, county by county. And, you know, in Texas, we have 254 counties, and like, I don't even know how many courts. Most counties have multiple courts within them. So we're talking about, you know, from an accountability perspective, an incredibly difficult undertaking. Which is why I think it has to be from the ground up. I think it has to be a dual strategy. A top-down strategy is not going to get the, you know, the places and, you know, wherever to necessarily comply when there's nobody watching them. And that's one of the things that we're really concerned about, is just access to being able to observe hearings. And one thing that's interesting about the pandemic is that more and more hearings are online. And so actually Fiona Apple, interestingly enough, is now waging a campaign to continue this trend of online access to court and bail hearings, which is super exciting. And it's great that she's bringing that attention to it. But I think it's very important for people on the ground in their local communities to be monitoring what's happening in their courts and in their local jurisdictions. And as part of that, you know, we actually see a fair amount of, I guess I would call it, accountability or interest in local prosecutor elections and sheriff elections, including, you know, whether you're in a rural or urban jurisdiction. And I think there's a lot of opportunity. I know people complain about elected judges being elected, but I actually think it's an opportunity for introducing democracy into you know, bail hearings and court proceedings. So I think it has to be coming from the ground up, in addition to these, you know, developments in constitutional law or laws that pass at the state legislature.
I think one of the interesting and challenging things about bail reform is that bail kind of legislation, right? It's not even legislation, it's policy, really happens at a county by county basis, as Amanda pointed out. And it is very difficult to know, even within a state, how things are done in all of the rural counties. And there's been a lot of good, you know, stuff published lately about, you know, how the rural access to justice, you know, lags urban. And I think that's really important to consider. I think something I've noticed in my kind of bail empirical work is that there's just a great variation of release rates nationally. And people, like you said, Amanda, you know, we need on the ground efforts, but I think most people don't even know. We need more transparency too. Right? People need to know what their bail release rate is in their county, right? We don't often know that. And, you know, the counties we looked at, no joke, it was, you know, some counties let out 5% of defendants and others let out 95% of defendants. These are kind of, you know, state counties, the 75 largest counties that report. That's not even considering the rural counties. So, you know, especially where there is jail space in rural counties, are they detaining almost everyone? I mean, we don't know, right? There's so much we don't know. And I think should be a great effort to kind of collect data to figure out what's going on. And then also, like Amanda said, have these grassroots movements in these areas to say, you know, what does it look like here? I mean, one thing I got asked recently, and I, you know, hope that that it gets followed up is, you know, is there a way to figure out how much, for instance, Salt Lake City judges are charging for bail in general? And there's not, right? They're not collecting this data. They're not publishing this data. And wouldn't it be nice? I know Amanda and I would love to see that in our respective jurisdictions or nationally. It's just not available. And so just this lack of transparency really makes it more difficult, especially in these rural counties where you have, you know, prosecutors and defense attorneys, kind of the same few players making all the decisions, and nobody else knows what the heck's going on. So
I want to do a little plug here for a project we're working on that gets to that issue. How do you get the data? As you guys both know, you can go all over the nation and get jail rosters, right? There are probably more than 1,000 that are online where you can find out who's in jail. You can also often see how long they've been in jail. What you can't generally see is why they're in, what's happening in their court case, et cetera. And that's the kind of information that Shima's talking about, right? How much is the bail? When was it set? How long did it take to get a hearing? We've recently done a proof of concept project where we were actually able to use computer science to extract jail rosters, extract court data, and match it. And so we can actually see how long people waited from the moment of book-in to the jail for these various significant procedural markers, and we can see how much the bail is. But there are very few places where you can do that, right? Because the data isn't all available online. There are lots of places where it's behind a paywall. And this goes back in some ways to the video point Amanda made. And so I know Amanda wants to add in something on this, but I want to just say that I worry a lot about video, and on the one hand, I think transparency is great. On the other hand, the available data we have, which is old, it's a study that started in Chicago in the 1990s, and it ended about a practice of doing video bail hearings. The practice was terminated because the evidence showed that bonds were much higher for people whose bond was determined by video. And so I guess I'll leave that there and let you guys respond.
So on that, just to clarify, I meant more like the public being able to view. I agree with their problems with that, and I've seen that study as well. And I'm just thinking about, like, in 2000, before we filed O'Donnell and Harris County, Texas Organizing Project had been bringing attention to bail hearings that were happening that were really just completely abusive and clearly abusive. But the camera was shining into the courtroom, so they were actually in-person hearings that were being recorded so that people could monitor them. And I think having that public access to monitor piece is really important. And it doesn't necessarily, I'm not even necessarily talking about video. Like, you just can't get into these rooms most of the time. Like, it's an incredibly fundamental problem in having anything that resembles accountability in initial bail setting. I'm trying to remember the other point that I was going to make when I raised my hand, but you got me distracted by that interesting piece.
I'm talking about the data tracking on rosters and length of stay, and data on length of stay, and how you correlate that to
the other thing I was going to say, it actually went back to your question about the role of lawyers, is that I think that lawyers can play a role in a sort of like know your rights kind of campaign around bail setting as well, because it can feel super technical, and hearings can be, they're really meant only for lawyers to understand them, which is, a problem in itself. But I think there's a lot that lawyers can do to kind of mythologize what happens in courtrooms and help people understand what rights exist in bail setting.
So let me go to one other question I want to ask. You mentioned rights, and you just said demystify it. Now I'm about to mystify it right up. Sorry. I want to talk about one issue about why we hold people. Professor Baughman mentioned arrest, right? It starts at arrest. And something that I've been thinking about a lot, and I know the two of you have as well, is it's this question of who gets arrested, how they get in the door, and then what is the basis on which we hold people? I mean, most of us, I think, in the profession understand, but people outside don't, that the vast majority of people who are in jail have never had formal charges filed against them. They are literally uncharged, right? They're being held on the sworn testimony of an officer at a probable cause standard. What's the nexus between that kind of loose legal rule about being able to hold people before there are formal charges and this enormously wide net of everyone who gets held? I mean, what should the right legal standard be for how much proof there has to be and how much commitment there has to be by the prosecution to go forward? Nationally, declination rates hover somewhere between 17 and 25% of all arrests. People go through the court system and the prosecution declines the prosecution of the case. What's the standard here that we should be applying? And put it in lay terms. That would be awesome. Okay, there's deafening silence.
That's a great question. That's like a spend my summer studying question, not a off the cuff for me anyway. Maybe Amanda's really figured this out. But yeah, I mean, I've thought about all of this, the declination aspect, the arrest rates, but what is the right standard? I mean, I tend to kind of, to make it simple, like you're trying to get me to do, really think that when we're going to arrest, I think there should be, similar to kind of the bail standard, there should be serious charges, something that prevents that person from being able to be introduced to society safely, and however we articulate that, I don't know, but certainly we definitely have, over arrests, over criminalization. There's so many people being held and arrested, because it's just kind of, officers aren't given that discretion. And you're right, there is declination, but a lot of times there's mandatory arrest. I mean, you look at our statutes, so many things you have to mandatory arrest for. And also I think, and I'd love to do a comparative study, and Professor Turner at your school, kind of brought this up in comments in my paper, which I really appreciate. But she was saying, I'd love to see kind of a comparative rate of this. And this is something I'd love to see a comparison of. I mean, I know our arrests are higher. Obviously, our arrests are higher, our prosecutions are higher, and our incarceration rates are higher than basically any country in the world. And so, what are other countries doing? How are they maintaining safety in ways that we're not? I'd love to kind of study this and see what are their standards for arrests, or what are they doing to decline more cases. And to be fair to police, I mean, one of the papers I wrote about prosecutors, I studied this, and police are reducing their arrest rates, which is amazing, but also crime rates have gone down, right? You look at crime rates from the, from 1990s, but really from 2005, steadily they're going down, even though that's not our perception, that's what's happening. But prosecutions are not really quite following as, in a direct line. So I think prosecutors are still prosecuting a lot of cases, even though arrests are going down. But I'm kind of veering from your harder first question, so I'll stop there.
And I'll just put in a plug that for folks who want to think about prosecution, we do have folks from Fair and Just, as well as Kay Levine from Emory, joining us for our next criminal justice reform conversation to talk about exactly these issues. Amanda, you want to join on this?
Yeah, I guess I'll just add that, there's no question we over-police, over-criminalize Black, brown, poor people disproportionately. And the way we target those people is exacerbated at just about every phase of our criminal legal system. And so of course it's happening, initially when police are making decisions about what neighborhoods to be policing, what people to pull over, what folks to bring into jail, whether to arrest them. So we can't really have a conversation about bail without recognizing the way that folks are initially funneled into that system. I mean, I'm all for decriminalizing as much as possible, and we have a long way to go. And I'm also for minimizing police authority to arrest people for certain offenses. I mean, so folks have an idea where we are on that right now. This legislative session, we're working on a bill that would make it so that police officers could not arrest people for Class C misdemeanors. And Class C misdemeanors are fine-only offenses. You can't even be sentenced to jail, but people are being brought into jail. That bill came out of when Sandra Bland was arrested wrongfully and died in jail. So to give you a sense of how long we've been working on that bill. So we have a really long way to go when it comes to limiting police authority and discretion to arrest, and also decriminalization. And I would just throw, drug crimes and really most, if not all, misdemeanors into the decriminalization category.
So we have a question from I think it's Jordan Gross's question, so clearly another cynical law professor. And the question is, if in fact what we do is we distinguish, and this has kind of been the trend in criminal justice reform, to distinguish between violent and nonviolent offenses, misdemeanors and felonies, aren't we really just incentivizing upcharging by police? And on that note, I will simply share with this group, we have a study that we did in 3 prosecutors' offices about charging, and in one of the offices, a prosecutor said, well, nobody pleads from the street. And it was in a conversation about how you pick a charge, right? We build in systemic incentives for police and prosecutors, even if they think that a conviction is the right result, and that's why they're doing it. We are building in systemic incentives to upcharge, right? If we do that. Is that a fair concern? Is it the cost of doing business?
Yes, I'm as you can see, I'm chomping at the bit to answer this question. It's a great question. Thank you, Professor Gross. But this is why, the 7 things I talked about, particularly presumption of release and a detention net, setting a detention net for jurisdiction is critical. So under my proposed optimal bail bill, right? we would release basically all defendants except for consider those forcible felonies under some sort of risk assessment where we're looking at data, but we're also looking at the racial impact of that data to make sure it's not discriminatory, but also just figuring out if they are unsafe to release and if there's no condition where we could release them safely. And this would be, they pose a serious risk to a specific individual, right? Those kind of, a higher bar. The government has to prove this. And then, yes, they can be detained. But yet still in that jurisdiction, we still have a goal target of releasing 90%. So I guess, yes, it could lead to people, overcharging, prosecutors saying, well, I'm going to call this a forcible felony so that they have a less likelihood to be released. But two things happen. One, they still, if there is a goal, they still have to meet that goal of, releasing like DC does, 94 to 90% of people. And two, then the prosecutor has to deal with it, right? Nowadays, it's kind of like the default is detention, and unless there's evidence proven, and in this model, this would be the prosecutor then has to kind of file a further motion and prove that that person should be detained, prove specific individuals they're a threat to. And honestly, I think some prosecutors would be like, I don't have time for that, and that's a great thing for bail reform.
This is a really good question, and my public defender friends have posed this to me when talking about Rule 9 and Harris County and the O'Donnell settlement, this exact issue. And that's part of why I really love Professor Baughman's paper of like presenting these must-haves as a package, because there's really this whack-a-mole effect that we see in reform. And it's really important to think holistically and to think about what are, quote, unintended consequences to something that might look tempting, but in fact might result in additional surveillance, incarceration down the line, wealth extraction, and that kind of thing. So I think one of the advantages to, how Professor Baughman lays it out as the package deal almost, is that folks who are not in this like wide net of release that is initially cast would get attorneys, would get individualized hearings, would still have a presumption of release. And in some ways, just because of the sheer numbers of folks that we have going through the system, it would free up resources for those guarantees to be much more meaningful as well, for the right to counsel and the individualized hearing, et cetera.
So we have both prosecutors and judges and some former judges who are joining us today on the webinar. And one of the questions I've gotten is, what can judges do to advance the cause of bail reform? And presumably that question is not, what do I as a judge do? Because that's pretty easy, right? But what do judges do to help the system move forward? So let's start with that one. What can and should judges do within the scope of their ethical obligations to make some change here?
I'm tempted to put my cell phone number in the chat just so I can like have an individual conversation about that. Because I think, in Harris County, we saw an example of that. Like we saw judges who were fighting reform for years as they fought this lawsuit. And then judges who came in and issued a standing order. So used the administrative rules that were available to them to issue a standing order that basically created a right to pretrial release for most people charged with misdemeanors. Judges across Texas can and should be doing the exact same thing. I think also judges, unfortunately in Texas, judges have, I believe, an outsized role in accountability for indigent defense, the way that our system is structured. That being said, judges can and should hold defense attorneys accountable when they're not filing any pretrial motions and they're not visiting their clients in jail, because they really contribute to this problem of meet and plead for folks who are being held pretrial. So those are just like a couple ideas, but like call me, email me, we can drill down in your courtroom about what you can be doing around this.
I love this, a judge asking for our opinions. This is our dream, right? I agree with everything Amanda said. I would say three things. One, read Amanda Woog's paper. It's amazing. And it really talks about the kind of problems with, we get great law, but then what happens when judges don't follow it? And this happens all over with bail reform. This is why we're still talking about it, right? After third iteration of bail reform is because we don't have enough judges interested. And so one thing you could do is, read Amanda's paper, talk to other judges, right, at judicial conferences, talk to even your colleagues. Something I noted, I told you earlier about the detention rates. I mean, we noticed within a certain office, there's some judges that have, you know, again, 90% release rates, others have much lower. I mean, could you have a conversation internally to be like, hey, what about if we, you know, can release more people? I think those are the big things. And the other thing I would add too is, this is something I've heard over the course of my career many times from judges is, well, what if I'm the guy that releases the ex murderer, the ex, you know, burglar, the rapist? And honestly, I think first of all, the chances of that are very low, even amongst the most high risk felony offenders for previous violent crimes, charged with a violent crime. Their rate of committing a violent crime on release from bail is about 10%. Okay, so it's not, I mean, that's high. That's the highest it gets. And that's high. And those people usually are detained, right? But for the vast majority of people, the risk is as low as someone in the general public. So I think judges just need to be brave. I think we are, as part of the system, need to be brave and say, look, I'm defending the Constitution. I'm defending the presumption of innocence. I'm defending due process and giving this person the right to release. Now, whether they make a choice that is, you know, unlawful and do something awful, that's not on me. And their job is to protect that liberty for all of us. I mean, I think, you know, when you sign you take on your constitutional oath as a judge, you really do have the duty to defend the liberty of those that are charged and accused. I mean, that's part of the one of the most important things we do as lawyers and judges.
And I'll throw in one other thought, and this is an idea that David Ball, among others, have promoted. I think it's particularly true for small and rural and tribal communities. We have to be more transparent about the cost of pretrial detention. Right? It's not just the cost for the individuals, although again, you know, their due process rights should be the beginning, middle, and end of the conversation. The reality is we hide the costs of detention in a way that communities don't really have a chance to understand that we are choosing detention over hospitals, detention over schools, detention over roads, right? That those costs are very hidden. And you know, the folks who actually feel them the most are often law enforcement. We just released a report about rural sheriffs in Texas, and one of them said, my jail's overcrowded because there are delays in processing cases, and it's costing us as a county a fortune, right? That these are not good uses of public funds as well. And I think Missouri had an effort at this at one point, but I think transparency in what pretrial detention costs is a really excellent counterweight to some of those narratives. Joanna Landau, who's the chief of public defense in Utah, so you know, a fellow countryman, is asking, you know, what do you do about that public safety narrative, right? About the Willie Hortonizing, I'm dating myself, but the Willie Hortonizing of fear about what happens when someone's released, and how do you change that narrative?
I think one way, I mean, you're kind of, you know, you're really shielding judges individually when if you have what I propose, which is this, you know, a very tiny detention net with the presumption of release for most defendants, then it's not an individual judge that's kind of on the hook with the media as far as the whatever scary thing happened. It's everybody. It's the whole system. And so I do think that that helps the kind of, I'm scared as a judge to be the one in the, you know, highlighting the paper, even though I know in the last few years there have been efforts to educate the media so that they don't, because it really is an education issue. It's like, do you want civil liberties? Do you want due process? Because if you do, then you wouldn't kind of put the judge's name in the paper that released the person that did whatever, because they were just doing their job. They're following the Constitution. So I mean, it's a lot of, to answer Joanna's question, there's a lot of kind of education needed, but I do think that having the presumption be released kind of absolves judges from that determination. And really, we do know based on data from lots of people, the data I gave you earlier, this was 15 years of data, over 100,000 defendants, 10% risk of a violent crime with someone that's the most serious. So 4 felony violent crimes, and being charged with a felony. We're not talking about misdemeanor people. We're talking about the most serious, and the risk of them having a violent crime on release from bail is 10%. So it really is pretty low. And I just hope that we can educate judges of that's the case.
Let me follow up on that and ask, what about the function of court watching? This came up in the conversation about video. It's something that we've seen, historically, court watching was often done by victims' rights organizations, police unions. Used to see these statistics, for example, who had the shortest dockets, right? Which judges could keep the cases moving the fastest. And one of the pushbacks has been, I think, to put community members in courtrooms as court watchers to track things that community members care about, like, did you address the defendant by his or her surname, right? Were you on time to court yourself, Judge? How much time did you give the defense counsel to actually make a presentation? And so I think perhaps another piece of that, right, is changing the public narrative about what goes on in court, where we are rewarding, gathering data about and rewarding behaviors that won't be captured in court records, right? No one notices whether you're polite in a court record, but that are useful to communities when they make decisions about who can and should be judging in their communities. Amanda, do you have more thoughts on that? Because this is really a large part of what you and Nate are thinking about.
Yeah, I mean, narrative is a huge, every problem is an opportunity. It's like my optimistic way of thinking about it, but it's a place where a lot of efforts need to focus in the so-called bail reform movement right now. I think that we need to celebrate the successes more. Like, bail reform is mostly about people returning home to their families and jobs. I also think, as far as like research is concerned, there's more research that could be done about the effects on families and communities when someone is home pre-trial versus in jail, which are of a gigantic magnitude. The Ella Baker Center a couple of years ago did this really great report about the financial impact of incarceration on families, which included jail and prison. But you can really, I think we need to document and educate people on the reverberating effects of pretrial incarceration. Shout out to Paul Heaton and Sandy Mason and Meg Stevenson's paper that did do that we use all of the time. But I think it's hard to be on the defense here. Like, this is a success story when people get home to their families. And really the failures of the system are when people, by and large, the failures of the system are when people are held in jail, not when they're released. And I think that's another story that needs to be told as well. And media, I hate to complain about the media because so many people do, and they're also really excellent journalists who are incredibly thoughtful and do a great job covering this. But too often media are just picking up the talking points from law enforcement that really are not grounded in data or what we know to be the day-to-day experiences of the cash bail system, whether someone is released or not. And I think, to your question, Professor Metzger, court watching can play a really big role in that narrative shift. When people see those hearings in Harris County a couple years ago, the initial bail hearings, they kind of make your stomach turn. And I started the talk by talking about Ms. O'Donnell, the named plaintiff in Harris County. And it's no coincidence that the district court judge, Judge Rosenthal, when she approved the final settlement, she started with a quote from Ms. O'Donnell. And I think it's incredibly important for media and others to be centering those stories, which are tragedies, which have been tragedies over and over every day in the cruel minutia of this system, but can then become success stories when we turn the system on its head. And that's a really big narrative shift that needs to happen, but is very much backed by the data and the stories that we know.
Well, thank you for that. So we are almost at the end of our time here, and I want to thank everyone who joined us. I want to give you each a minute, and I literally mean a minute, if we're going to be respectful of everybody's time, to wrap up and share with us kind of your parting thoughts on where we go from here.
Okay, I just want to thank you, first of all, for, or last of all, for having me here. It's been so fascinating, and I love all the questions, and thanks for all that. I think just overall, to sum up everything I've said, I think so important as we're thinking about bail reform to have a presumption in our bail policy, whether county or state, of release. for most defendants, and really set a goal in your county of we're going to have 90% release rates. And it's been proven in DC for many years. They've been doing it since the 90s. And so I think other jurisdictions can learn from this. Let's learn from this federalist model that we have in America, right? Where it's worked in DC. Can we try it in other jurisdictions and see all of these other bail reforms that we've tried, money bail, risk assessments alone without those goals mean nothing. We're not going to improve bail in this country unless we really kind of do those two things.
I agree completely with that. And I think my parting words would be, don't trust the professionals on this. We're at a critical juncture in bail reform, or don't only trust the so-called professionals on this, because there are people who are doing the work every day in community bail funds and court watching and holding judges accountable, who have visions for what a pretrial system should look like. And to avoid the pitfalls that Professor Baughman has talked about with these first and second waves of so-called pretrial reform, I think it's really important to center the experiences of people who have been harmed by the system and what they see as the solutions.
Well, I want to thank you both, and I want to say thank you again to the SMU Law Review for having the really ambitious vision of doing something that we don't do often enough in the academic world, which is to say that we want scholarship to speak to practice, and we want practitioners to inform scholarship. And this symposium really epitomizes that philosophy. It's what got us excited about it at the Deason Center. We believe in that kind of praxis between the academy and the world of people whose lives are justice impacted. So just a quick reminder that we do have 2 of these conversations already available on our YouTube channel. We have 2 more coming up, one about prosecution reform that will feature Miriam Krinsky from the Fair and Just Prosecution Organization and Kay Levine from Emory Law School. After that, we'll be speaking with Chief Justice Bridget McCormick from the Michigan Supreme Court and Professor Irene Joe from the University of California at Davis or Irvine. Oh gosh, I've forgotten. Anyway, Irene Joe, who's my friend from New Orleans. And Irene and Bridget will be speaking about public defense. And once again, just a big thank you to Professor Baughman and to Amanda Woog for the amazing work you both do and for sharing your insights and thoughts on bail reform with us. Thank you all for joining us. We will look forward to seeing you at future events.